Welcome to the Juvenile Delinquency Courthouse. This video has been created for youth who are in custody and those who are out of custody, and their families and/or legal guardians. This video will guide you through the procedures followed by the San Diego County Juvenile Delinquency Court in carrying out its goals and responsibilities as mandated by law: to provide treatment and rehabilitation for minors, hold them accountable for their behavior, protect the public, and assist victims and the community to recover their losses. Young people who are accused of breaking the law when they were under the age of 18 come to juvenile court. In adult court, such people would be called defendants. But in juvenile court, you will be referred to as the minor or the ward. If the charges against you are found true, you will be placed on probation, which will include some punishment and treatment. In this video, we will look at each stage of the juvenile delinquency process for minors who are held in juvenile hall and those who are not. For each court appearance, parents or guardians of minors not in detention arrive at the courthouse with them. Parents or guardians of a minor in detention will see the minor during the court hearing in the courthouse. Inside the entrance of the courthouse, you will pass through a metal detector. In some cases, you may have to remove items such as your belt, shoes, jacket, or jewelry. While inside the courtroom, all cell phones and pagers must be turned off. Appropriate dress attire and conduct are required of minors, their parents, guardians, and any accompanying family members. Both your clothing and conduct should display respect for the court and show the court that you take the case seriously. If the attire and conduct are not in compliance with the court rules, your case may be rescheduled, or the court may take appropriate action, such as ordering a person to leave the courtroom. Depending upon the severity of the conduct, the minor may be detained. Visit www.sdcourt.ca.gov. Click on Juvenile when you go to court. You must first report to the reception window. You will be directed to your courtroom and instructed to wait in the seating area outside that courtroom. If you have small children with you, they may go to the children's waiting room, which is available Monday through Friday from 8 a.m. to noon. Unless you intend to hire an attorney, the court will appoint one to represent the minor. Once you're in the waiting area, the attorney will contact you to discuss your case before your court appearance. The purpose of that meeting is to gather information, such as how the minor is doing at home and at school, and about the circumstances of the alleged offense. It is important to understand that the attorney represents the interests of the minor, not the parents or guardian. Once inside the courtroom, you will see a number of courtroom participants. The judge sits at the front of the courtroom on a raised platform known as the bench. The tables facing the bench are the counsel tables. At one sits the deputy district attorney, who is responsible for bringing the charges to court and for proving that the charges are true. Seated at the other counsel table is the defense attorney, who represents the minor. The defense attorney provides legal advice to the minor and protects the minor's rights. The minor sits next to the defense attorney. The parents sit in the back of the courtroom behind the DA table. If the minor or parents require an interpreter, the interpreter will sit near them. Seated near the judge's bench is the courtroom clerk, who keeps track of all the orders of the judge, and the court reporter, who records the words that are spoken in court. A sheriff's deputy sits at one side of the court as a bailiff, maintaining security in the courtroom. A probation officer acts as the presenter, who makes recommendations to the court about your case, provides last-minute case information, and researches probation issues at the court's request. When the hearing concludes, probation officers will provide relevant information to any departments or agencies involved in your case. You may obtain information from the service desk, which is located in the lobby of the courthouse. In some cases, you may receive a copy of the minute order immediately following the hearing at the service desk. A minute order is prepared by the court clerk and reflects what occurred in the court hearing. The courtroom probation officer will let you know whether you can immediately pick up the court minute order or if it will be mailed to you, as well as when your next hearing will occur. You may also obtain information from your probation officer. The juvenile delinquency court process consists of a series of hearings. The first hearing is either a readiness hearing for a minor who is not in custody, or a detention hearing for a minor who is in custody. The next hearing for a minor who is in custody is a readiness hearing. Whether the minor is in or out of custody, the next hearing after the readiness will be a settlement conference. After that, there may be a jurisdiction hearing, which is the trial. This hearing is sometimes called an adjudication hearing. If the minor admits the charges at any hearing, or if the charges are found to be true at the jurisdiction hearing, the next hearing is a disposition hearing, which is like a sentencing hearing in adult court. After that, there will be periodic review hearings. When the minor is out of custody, the first hearing is a readiness hearing. At this hearing, the judge informs the minor of the charges he or she faces. The defense attorney will meet with the minor before court to discuss the charges. The charges may be different than the ones the minor was arrested for. The deputy district attorney bases the charges on the police report and other information from the minor's history, including behavior at home, school, and in the community. When the case is ready to be heard, the parents and the minor will be asked to enter the courtroom. In some cases, the minor may admit to the charges at this hearing and proceed directly to the disposition hearing to receive punishment and treatment as part of probation. However, in some cases, the minor will not admit at this stage, and the matter will be scheduled for future hearings. When the minor is in custody, the first hearing is a detention hearing. This is a brief hearing to determine whether to keep the minor in juvenile hall pending the outcome of the case, return the minor home without restrictions, return the minor home on home supervision, or release the minor with electronic monitoring. The detention hearing is not the time to litigate the merits of the case. If the minor intends to fight the charges, that will be done at a future hearing. The minor will also be arraigned, which means the judge will inform the minor of the charges he or she faces. Before the detention hearing, the minor's attorney usually visits the minor in the detention facility on the morning of the hearing to explain the procedure and gather information about the minor's home and school environments. Parents, you should bring anything that you think will be useful to the judge in making a decision concerning detention, or that you think will be helpful in taking care of your child while he or she is detained. This would include medications, school records, or records of recent medical visits or hospitalizations. When the minor's case is ready to be heard, the parents will be directed to enter the courtroom. At this hearing, the probation officer, deputy district attorney, minor's attorney, and the parents provide information to assist the court in making a decision that is in the best interest of the minor and protection of the community. The judge must balance a number of factors, including the safety of the minor, the safety of the community, the likelihood the minor will flee the county, and the minor's violation of any prior court orders. Helpful to the court in making this decision is how the minor is doing in school, whether the minor is following the rules at home, the minor's use of drugs or alcohol, and the minor's association with others. If the minor is released at the detention hearing, he or she will usually be required to comply with restrictions that will include curfew, school attendance, and return to court. A probation officer monitors the minor's compliance with the conditions of release. Other restrictions might include home supervision, where the minor is contacted daily by a probation officer, or electronic monitoring, where the minor is monitored 24 hours a day, 7 days a week, using computer technology and a tracking device that the minor must wear. If the minor is in custody, the next hearing will be a readiness hearing. The minor may admit the charges or may ask that a settlement conference and jurisdiction hearing be scheduled. Whether the minor is in or out of custody, the next hearing after the readiness is the settlement conference. Before this hearing in the judge's chambers, the minor's defense attorney, the deputy district attorney, and the judge attempt to reach an agreement to resolve the case without the necessity of a trial. If at the settlement conference the minor admits responsibility for committing the offense, the judge will ask the minor a series of questions to make certain that the minor understands his or her rights and understands the consequences of admitting responsibility. If the minor admits responsibility, A disposition hearing generally will be scheduled to be heard at a later date, usually 2 to 3 weeks later. Sometimes the disposition hearing takes place immediately. If the minor does not admit responsibility, the case will be scheduled for a trial called a jurisdiction hearing or an adjudication hearing. At this hearing, evidence and witness testimony are presented to the judge. During the jurisdiction hearing, the Deputy District Attorney must prove the charges. After the Deputy District Attorney questions his or her witnesses, the defense attorney will have the opportunity to question each of those witnesses on what is called cross-examination. After the Deputy District Attorney presents all of his or her witnesses and evidence, the minor's defense attorney has the opportunity to present witnesses and other evidence on behalf of the minor. After the minor's attorney questions his or her witnesses, the Deputy District Attorney will have the opportunity to cross-examine each of those witnesses. If at the conclusion of the jurisdiction hearing, the judge determines that the charge or charges are not true, the case is dismissed. If, on the other hand, the judge determines that the charge or charges are true, the judge will make a true finding and the case proceeds to a disposition hearing. The disposition hearing is the time when the judge will impose punishment and treatment. The judge will review the minor's social study report that is prepared by the probation department. The judge will hear comments from both the minor's attorney and the Deputy District Attorney. The judge may then hear comments from the minor's parent or guardian, as well as from the minor. On some occasions, victims and victims' family members may make a statement. The judge will decide how the minor will be rehabilitated, how he or she will repair the harm caused to the victim and the community, and what sort of punishment is necessary. Dispositions may include community service, home supervision, electronic monitoring, counseling or treatment, restitution to the victim, court fines, or any other term the judge finds is appropriate. The minor may be committed to Kearny Mesa Juvenile Detention Facility, East Mesa Juvenile Detention Facility, Girls Rehabilitation Facility, Juvenile Ranch Facility, Camp Barrett, the Youthful Offender Unit, a state juvenile facility, or a residential treatment facility where the minor lives while receiving treatment. These requirements, along with others such as attending school, drug testing, and obeying all laws, are court-ordered conditions of probation. When you leave the courtroom, you may go to the service desk in the lobby to go over the court-ordered conditions. You must comply with these orders to successfully complete your term of probation. Usually, you will be placed on probation for 1 year. If you do not comply with your conditions of probation, you will be brought back to court for a violation of probation and a new disposition hearing. At the conclusion of your probation period, the court will review your case to see if you have successfully complied with all the probation requirements. If you successfully complete all the terms and conditions of your probation, you will be taken off probation, and the court will terminate jurisdiction in your case. If you have not yet completed the terms of your probation, you will most likely remain on probation for a period of time sufficient to allow you to complete the outstanding conditions. For most offenses, a minor could be on probation until age 21. However, most minors complete probation within 1 year or before the age of 21. If you successfully complete probation, you may be able to request to have your juvenile record sealed. This means you have a chance to learn from your mistakes, make amends to the victim and/or community for your actions, and not have this juvenile record count against you in the future. We hope the information provided in this video helps you understand how the juvenile court system works in carrying out its mandated duties to provide treatment and rehabilitation for minors, to punish them and hold them accountable for their behavior, to ensure public safety, and to protect victims and the community by helping them recover their losses. For further information, please visit San Diego County Superior Court's website at www.sdcourt.ca.gov or the San Diego County Probation Department's website at www.sdcounty.ca.gov/probation.